Thank you for joining us today. My name is Dan Hartledge. I serve as president of the Louisville Forum. We typically meet on the second Wednesday of every month at Vincenzo's restaurant in downtown Louisville. But these days we are meeting virtually. The meeting is occurring by way of Zoom and is also being live streamed on Louisville Forum Facebook page. The Louisville Forum is a nonpartisan public issues group founded in 1984. The forum hosts debates and discussions of contemporary and sometimes controversial public policy issues that affect the greater Louisville community. Although we may take up issues that have a national interest, we try to highlight them from a local perspective. And the Louisville Forum never takes a position on an issue. For more information on the Louisville Forum, our programs, or to make reservations, please visit our website at louisvilleforum.org. Our topic today is Governor Beshear's COVID-19 restrictions and mandates. Is he overstepping his authority? Dating back to the spring, since the pandemic first gripped our nation and our state, Governor Beshear has almost on a daily basis addressed Kentucky residents on the impact of the virus and how it's progressing in the state. And he provides updates on the number of cases, numbers of hospitalizations, and a daily update on virus-related positive tests and virus-related deaths. The governor also appeals almost every day to Kentuckians to take measures to slow the spread, to stay home, to avoid crowds, socially distance, wear a mask. But some say his restrictions and mandates have gone too far. In late March, the governor ordered all non-life-sustaining businesses to shut down in an effort to encourage people to stay home. Some business owners and operators and their workers complained vehemently about those orders, saying the governor was overstepping his authority and irreparably harming the businesses and the many thousands of people who work for them. Then in June, attorney Chris Wiest, one of today's panelists, filed a lawsuit against Beshear on behalf of a Northern Kentucky daycare, a racetrack, and a cafe. Attorney General Daniel Cameron joined in on that suit, which is now before the Kentucky Supreme Court. And suits have been filed against the governor for his requirement to wear masks in public and his class size requirements for daycare. And then there is the governor's ban on in-person worship and his ban of out-of-state travel. But the governor says the pandemic represents the gravest threat to public health in more than a century, and he is empowered to issue such orders during such a dangerous time. To do otherwise would place more lives at risk, he says. And many in Kentucky do agree with him. So to discuss both sides of this issue are two attorneys who have already been quite outspoken on the subject. Chris Wiest, as I noted, has a suit challenging the governor before the state Supreme Court. Chris is a Northern Kentucky attorney. His law degree was earned from the University of Cincinnati in 2004. And then we have Sam Marcosson, a professor at the University of Louisville's Brandeis School of Law. Sam is a graduate of Bradley University and Yale Law School. So thank you both, gentlemen, for being here today. And Chris, I would like to start with you. The question today is whether Governor Beshear is overstepping his authority. So if you could take about 3 minutes or so and address that question from your perspective, Chris, the floor is yours.
Yeah, and I think, you know, there's a lot of, it seems like it's a simple question, but it's actually far more nuanced. And, you know, I think we ought to begin this discussion where we began the lawsuits. And I guess, you know, we didn't mention this, but I've also done, you know, 3 of the federal lawsuits that we've brought in relation to this. And there's federal constitutional rights and there's state constitutional rights, and they're not necessarily the same. And when we look at the federal constitutional rights, I don't think that there's a question at this point, at least in terms of whether the governor has violated the United States Constitution, because numerous federal courts in Kentucky and the United States Court of Appeals for the Sixth Circuit have ruled that he has. And so, you know, when we're talking about the church ban, That has been up to the Sixth Circuit Court of Appeals. There were 2 Saturday decisions that were rendered in a row, once on drive-in and drive-around services, and then the Saturday injunction that we obtained in the Roberts case that says that, look, he has to treat, and I want to be clear, it doesn't say that he can't ban church. It says that he cannot treat churches worse than similarly situated secular activities. For instance, they were allowing people to gather and congregate at bus stations or airports, but not sit in a church pew. So I think, and then, we had the travel ban also in the Roberts case. The governor didn't appeal that. Instead, he changed it. I'm glad that he did, to make it a travel advisory. And then we had the Ramsek case in the federal court system dealing with political gatherings and protests, where there was another preliminary injunction that was issued. The governor has appealed it to the Sixth Circuit on that question, on whether or not he can ban political gatherings and protests. It was focused at the Capitol. I think the opinion's broader than that. And those are kind of the federal rights that are at issue. Then we can turn to the state court action that was filed, as you mentioned, in June in what I like to call the Speedway case, Florence Speedway case, that deals with statutory issues, administrative regulations, and whether or not he had to follow the requirements of issuing those. And then there's really fundamental constitutional issues. And I don't want to dig in the weeds. I want to kind of keep it at 20,000 feet. But I think the real question is whether or not there are standards within it's called Chapter 39A, the Emergency Powers Act that he's been using, and whether or not there's standards there, whether or not it violates Kentucky's separation of powers, which has some of the strongest separation of powers provisions in the entire country, that says that the executive cannot legislate. And I know for a fact there's going to be legislation dealing with this in January by our General Assembly. So I don't think it's just me that thinks that there's constitutional issues here. I think a lot of people do. And obviously, we had a very robust argument in the Kentucky Supreme Court about whether or not the governor violated the Constitution and the statutory provisions of Kentucky law. And that came on the heels of a favorable ruling for my clients in the Boone Circuit Court, where they said, the circuit judge said, yes, he did, issued a fairly robust, thorough decision that said that, look, you cannot simply delegate sort of emergency lawmaking powers to the governor. And then one final point, our arguments don't leave the governor powerless to deal with the COVID restrictions. He's got administrative rulemaking powers under Kentucky law and in Chapter 211 to do some administrative regulations that will allow him to do a number of things that he's done. He just has to follow the law in doing it. And that's been our position all along.
Okay, thanks, Chris. And Sam, that takes us to you. From the way you see it, when it comes to handling the pandemic, is Governor Beshear overstepping his authority?
Thanks, Dan. The short answer to that is no. I don't think that he is or has overstepped his authority. And I would also add to that, I always try to start a presentation like this with areas of agreement. And that's a little difficult in this case, but not impossible. Chris and I think, do agree that there are both federal and state constitutional issues that have to be talked about and thought about, some of which have been discussed in some of the federal cases that Chris mentioned, and some of which on the state level are being discussed and considered by the Kentucky Supreme Court. The first thing I want to say is that where I don't agree with Chris is that the governor violated any First Amendment rights. I certainly grant that the Sixth Circuit felt differently. My view of the Sixth Circuit decision is that it was a dangerous and unjustified application of some first principles under the Free Exercise Clause. Chris is quite right that the key question is whether religion was treated differently, worship services were treated differently from similarly situated types of activities. And the fact that one of the Sixth Circuit judges talked about car washes which were not shut down, as if they are similarly situated to worship services, is quite revealing about how the judges were looking at this and comparing things that really are not similar. So in my view, the limits on worship services was entirely constitutional, that similar events at which people would crowd for a great length of time together indoors, those were also banned. Things like plays, things like University of Kentucky or University of Louisville basketball, those were also covered by the order, and they were similar. I do think that the key issue in the state suit is about both whether Chapter 39A is itself constitutional. It's important to note that the Attorney General and the plaintiffs are arguing not just that the governor exceeded his authority under 39A, but the 39A in and of itself is unconstitutional on the grounds that somehow it delegates legislative authority. And it doesn't. It gives it's one of the most detailed statutes you could ever read in setting forth the criteria that permits executive branch action. It's very much like, in some ways, a criminal law that says under these circumstances, when these elements are met, a prosecutor can bring a case. If the prosecutor brings that case, the prosecutor, believing that those elements are met, the prosecutor isn't using legislative authority. The prosecutor is using the executive authority that the statute vests in him or her to implement the law. And that's exactly what Governor Beshear has done. He's implemented 39A. The notion that that somehow violates the separation of powers is, to put it bluntly, a radical assault on more than 60 years of decisions from both the US Supreme Court and the Kentucky Supreme Court that permits delegations as long as there are guidelines, as long as discretion is suitably limited in the statute of legislative direction to an executive officer. And if the Kentucky Supreme Court agrees with that, it would totally undermine the system of government that we have in Kentucky. And it's this project that is similarly at issue at the federal level as in attacks on federal statutes as well. And I think that's very much what's at stake here. And I'm hopeful that the Kentucky Supreme Court will find that both 39A is permissible and that the governor has exercised his authority responsibly under 39A.
Okay, thank you. And again, submit questions, if you would, to the chat on Zoom. You can also do them to Iris directly if you'd like for them to remain confidential. You can text them also at 502-741-0969. And I've got one I'd like to go ahead and get us started with, and then see what you've got. First question out of the box: what are the General Assembly's powers regarding restricting the governor's authority? And at what point would legislators be overstepping their authority if they were to do that?
Yeah, I can answer this. We did a deep dive, obviously, preparing to argue the Speedway case. And the short answer is that the governor has no powers under Kentucky law other than there's very specific enumerated rights, for instance, to be the commander-in-chief. But in terms of exercising emergency powers, he has no plenary emergency powers or really any powers, other than very specific enumerated ones, for instance, to issue pardons, other than what the General Assembly gives him. And they have the ability to restrict him, and I don't think there's much he can do about it. If the General Assembly were to repeal 39A, I don't believe they're going to do that. I've seen some drafts of some bills that legislators are circulating. I think what they're going to do is curb the time that these orders can be in effect without calling the legislature back in. But they have the absolute right to curb and cabin the governor's powers and discretion in any way that they want, really, in terms of the use of these emergency powers or even emergency regulations, if they choose to do that.
Yeah, I don't disagree fundamentally with that. Maybe very much at the margins, there could be arguments in certain circumstances that the governor has inherent authority as commander-in-chief, as Chris just mentioned. I think that those would have to be argued, if you're going to argue them seriously, only in situations where the governor is acting in an emergency, and not just in an emergency like the pandemic we're facing now, but one in which the legislature can't meet or is prevented from meeting by the circumstances of the specific emergency. In a situation that Chris just alludes to, where the legislature is actually meeting, which would sort of take that off the table, and enacts legislation to change what we have now in terms of emergency powers under 39A, I mean, the legislature could do that. And hopefully, if they do, which I think there's every chance that they will, if they do, they'll do it in a way that is thoughtful and careful and does not, as the virus continues to rage, does not unduly limit the governor and make the pandemic worse.
So explain what that looks like. You've got, I guess, how does the General Assembly step in when they're not in session to control or to restrict those powers? And the fact is that we're in a deadly pandemic. If that's not an emergency where he needs to exercise emergency powers, what is?
So the short answer is they cannot call themselves into session right now. There's no ability for them to do that under the Kentucky Constitution. The governor can call them into session. I did a case in 2013. It was a redistricting case. I did it with the ACLU in federal court. And then Governor Steve Beshear called the General Assembly into session so that the General Assembly could draw the maps instead of the federal judges. And so only the governor can call them into session for now. I think we're going to see a House bill that's going to involve a constitutional amendment to allow themselves to call themselves back into session. But currently that's prohibited under Kentucky's Constitution. And so there is nothing they can do until they meet in January.
And that, to me, I agree with that, of course. I think that points out why it's important that the governor have between sessions robust emergency powers that almost every governor in the country has, and that the lawsuit that Chris and the Attorney General are advancing would undermine. Because, again, they're not just saying that the governor has exceeded his powers in the 39A. They're saying that the General Assembly exceeded or violated the Kentucky Constitution in its enactment of 39A, certainly specific provisions of it. And if that's true, then presumably the General Assembly couldn't enact a provision that, under at least the theory that the Attorney General is advancing, would violate the separation of powers by delegating legislative authority. And that would mean that no matter what the General Assembly does, the governor wouldn't be able to act to deal with an emergency because it somehow violates the separation of powers. I think that's a deeply ironic argument that somehow the General Assembly working together with the executive when it comes to first passing 39A and then the governor utilizing it, that violates the separation of powers, but a court stepping in and imposing a radical theory that would limit the other branches doesn't violate the separation of powers. In my view, it's the role of the Supreme Court that the plaintiffs in the Speedway case are urging that violates the separation of powers by having the Kentucky Supreme Court, if it did what they want, overstepping its authority.
All right, Iris, I'm sure you have questions coming your way.
Thanks, Dan. So receiving a couple of questions, and I'm going to do my best to consolidate. And Chris, within your remarks at the top, you mentioned some play-by-play of some complaints filed, the status of some of these cases, and how there was some follow-up action that intervened. Could you actually elaborate on some more of the play-by-play, the cases that have been pursued and now challenged at the Supreme Court level, at the state Supreme Court level, and sort of the latest of outcomes, rulings, and what to look forward, moving forward, I should say?
Yeah, this started with, I think everyone in March wanted to give the governor wide berth, but what really did it was when the state police were sent out to churches to put notices on cars, and they were taking down license plates on Easter Sunday. And so we filed the following Wednesday the Roberts versus Nice case in the federal court up in Northern Kentucky in the Eastern District, challenging both the travel ban and the ban on in-person worship. And Judge Bertelsmann, a Carter appointee, struck down the travel ban. The governor amended it and basically copied what Governor DeWine did in Ohio, which was a travel advisory instead of a ban, because interstate travel is a fundamental right. If you really hate where you're living, at the end of the day, you can always leave the state. and denied injunctive relief on the church ban. That went up to the Sixth Circuit, and on a about a week later, they issued an injunction pending appeal on the Roberts case on the church ban. That case has gone back down to the district court to figure out whether or not it's moot, because the governor has since lifted the ban on in-person worship. There's I think a 50% capacity requirement that we don't intend to challenge. There's questions about whether it's moot. There's some federal doctrines about why it might not be. So that's back in front of Judge Bertelsmann pending probably some more briefing. And then the second case that was brought was on political gatherings and protests. It's styled Ramsick versus Beshear. That was filed in the Frankfurt division, again, federal court. We obtained a preliminary injunction in July. The governor appealed that. And so that is, actually, I just got an argument notice yesterday. That is set for argument in January in the Sixth Circuit Court of Appeals. And then there's a couple other federal cases too. They're kind of on hold, dealing with the eviction moratorium and the CDC order. I think we need to talk about that. And then the state case was brought in June, which was the Speedway case. That was argued in September in the Kentucky Supreme Court, and deals with some of the issues we've been talking about today. If I had to bet when they're going to issue a decision, I was kind of hoping we might get one in October. They release their decisions like every month and a half. They have a minutes release day. And so the next one I think is December 15th. I kind of think we might get the opinion then, because there's going to be a little bit of changeover in the court. And I don't expect them wanting to hold that decision for, kind of a new justice coming on. So I do think we'll probably get the December 15th release date and a decision at that point.
So next question, we're getting a couple inquiring how Kentucky compares to other states and the debate there. What are some lessons learned? How are those debates playing out? And then things to come, so maybe potential outcomes or consequences experienced elsewhere that could be realized in Kentucky.
So in some ways, I think that, Kentucky has a robust double-barreled separation of powers provision, which makes it very unique. I don't know that there's many states that do. One of the states that does is Michigan, as their Supreme Court just struck down their Emergency Powers Act. We don't contend only that the act is unconstitutional. We also contend that there's a requirement in the act before the governor can act about obtaining a local certification or determination that he never did prior to issuing the emergency order. So there's a statutory issue too there as well. But I mean, I think we're probably closest to Michigan in terms of the actual text of the Constitution. I don't know that our Supreme Court is made up the same way as Michigan, though. So we may end up with a different result. And frankly, Sam may very well be right. They may decide, that this is okay. I say that kind of maybe because they issued a decision last year in the Bevin versus Beshear case, which was another unconstitutional delegation case about Governor Bevin's reorganization powers that then Attorney General Andy Beshear was bringing. And they said what they would never allow was sort of a unilateral, the executive can do whatever he needs to do between sessions. They would never allow that. And we do have, I mean, let's be clear. If you violate one of the governor's COVID orders, it's a crime. I mean, it's a Class A misdemeanor. So as he's issuing these orders, he is making law. And if you violate one of these orders, you can be held in prison for up to a year. I don't remember what the fine is. I think it's $500. It may be $1,000. So, that's part of what's going on. But I do think we're probably closest to Michigan. These cases are starting to percolate up into state Supreme Courts around the country, though, as we speak.
Sam, any thoughts on that?
Well, I think there's a somewhat more nuance that I would add into it than simply the separation of powers argument. That there are very different arguments that depend on what kind of rights are being asserted, and I think one of the issues one of the difficulties with the plaintiff's argument is that they treat almost everything that they assert is being infringed upon as if it's a fundamental right. On the one hand, obviously, I think it's obvious, free speech in the political expression case is, of course, a fundamental right, and the government has to have the strongest of reasons, the most compelling of interests, to justify limiting expression, and it has to show that the means it's chosen is narrowly tailored to achieve that goal. And I have no problem with that, and I think Chris and I would agree on that. But there are a big part of the basis for their challenge to the ruling is that somehow economic regulations that either shut down or limit the ability of businesses to operate, that somehow that such regulations violate a fundamental right, and that would, just as their arguments about separation of powers and delegation would upset decades of precedent, their arguments about a fundamental right to conduct your business and to be free of economic regulations would also upset decades of precedent going back to the New Deal. And so almost a century of precedent, both at the state and federal level. And that's what's so troubling to me about these arguments that they're offering up to the Supreme Court, and that, as Chris points out, were accepted in many respects by the Michigan Supreme Court. I'm relieved to have the belief that our Supreme Court has a very different view of these questions, as the Beshear versus Bevin case demonstrates, acceptance of the idea of delegation with limits. And 39A, as I've already suggested, has limits. And I think those limits will stand it in good stead.
A couple questions that I've received that are somewhat political, sort of taking a political slant to this, and I'll combine a couple. The legalese aside, this appears by some to be political in that it is Republicans attempting to neuter the Democrat governor. Comments on that?
Yeah, go ahead, Sam.
I was going to say, I think that you've seen that. With all due respect to Chris, he points out that the General Assembly wants, and almost certainly will, enact legislation to circumscribe these emergency powers. And this idea that they're going to try to initiate a constitutional amendment so that they can call themselves back into session. And these are all indications of at least part of the agenda here. I would also add that I think that the agenda is not just directed at Andy Beshear or necessarily the simple partisan differences between Republicans in the General Assembly or conservatives out in the public and the governor on the other hand, but it's also part of a broader legal agenda about undermining the administrative state, changing the state of the law, and pushing this agenda legally, whatever it happens to mean for this particular governor's term, because it's an assault on our modern, again, last 100 years of precedent about the non-delegation doctrine and separation of powers. I think that's very much what's at stake here.
Yeah, I disagree that this is Republican versus Democrat. I do agree that there's other things that are going on here, and Sam alluded to them. Fundamental philosophical differences about where the rights of government derive from the people versus the administrative state. And I think, who should be making the laws, the legislature versus administrative agencies. I do think there's a broader push. I mean, at the federal level, you're seeing there's something called Chevron doctrine. If you're involved in any kind of administrative litigation with the deference to an administrative agency, but I don't think that this is a Republican versus Democrat thing. I think if you had a Republican governor doing these kinds of things, that you would get the same bristle back with the legislature. And some of it isn't just philosophical. Some of it is, there is frustration, I think, within the General Assembly because they feel like the governor has not met with them, talked with them. They're out of session, so he just has basically ignored them. And, there is probably a little bit of, for every action, there's an equal and opposite reaction going on. But I do think that there is this, philosophical difference about who should be making the laws and how. And I do want to add, in Kentucky, unlike at the federal level where the administrative regime and governance kind of really popped up in New Deal and before that. In Kentucky, we did not allow for that kind of delegation, any kind of substantial delegation, until the mid-1960s. There was a case that came up that really changed the game in the 1960s. So we're not dealing with kind of long-standing, I guess it's long-standing, 40 years, 60 years is probably long-standing. And we've had the separation of powers provision since, I think, the late 1800s in Kentucky. But I don't know that it's as long-standing at the federal level. I would suggest that, at least from what I'm seeing, there is a fundamental philosophical difference about who should be making the laws and who shouldn't be. And it's more of a fight between the executive and the legislative versus Democrat versus Republican. At least that's my view of this.
If I could just add or respond to that very quickly. I think there is definitely that philosophical difference. And I think we agree on that. But there was equal frustration, maybe even greater frustration among the Republicans in the General Assembly about the failure or refusal of the last governor to cooperate with them, to consult with them, to work with them. I think there was some personality as well as some policy differences there. And yet you didn't see this kind of pushback against Governor Bevin. It was kept under the surface. They tried their best not to create more conflict than already existed. So I think there's a pretty good test case that shows that there is a partisan element to this, and that while they had some of the same concerns and complaints against Governor Bevin, they didn't act the same way towards him when it came to confrontation.
I'm going to disagree on 2 points. The legislative folks are by far closer to their constituents than the governor that represents an entire state. And in July, we had an economist come in and testify about the impact of the COVID regulations on Kentucky's economy. And he's, very, very well-renowned economist, teaches at the University of Kentucky. And it was a $28 billion impact as of July. We're going to lose him at this point. It's inevitable. We missed kind of the high season. We're going to lose at least 20% of our restaurants permanently. We're going to lose other sort of peak industries, probably, for the foreseeable future. And I think as these legislators are hearing this, the screams from the small business owners, and that's the biggest thing. It's the small business owners taking the hits. It's not the Walmarts. It's not the Amazons who, through their supply chains and otherwise, are really, weathering this and perhaps even thriving in these conditions. It's the small businesses who these legislators represent. And, the legislators are trying to go to the governor's office. They're not getting a response. I would suggest that if the same thing had been done by the Bevin administration, I think you would be seeing the same reaction. I could be a little wrong on that, but look at the number of veto overrides that the legislature did to Governor Bevin. And I think, it was a bunch of them. So I don't think, I think it's more than that. I think it's the impact of what he's doing, what the governor's doing, and what it's doing to small businesses and their small business owners, that's being felt in the communities that these legislators represent, that is definitely driving some of this.
So kind of circling back, this question goes for both, and Sam, we can start with you. A couple of different legislative actions are pending, right? So we talked about the legislature's ability to maybe call themselves in that will require a constitutional amendment change. What is veto proof? The governor does have the opportunity to veto there versus the legislature coming in and amending how these executive decisions using, state of the emergency may require statute changes. Can you just kind of clarify that process a bit more, particularly in the context that, both the House and Senate have achieved sort of super majorities, and how the politics could play out on those 2 pieces moving forward, regarding the 2 branches of government? Sure.
First, I think for the most part, there's a caveat to this, but for the most part, the gains that the Republicans made to extend their majorities even further make very little difference. The governor's veto is already a very weak veto, and they can override it by a simple majority anyway. So perhaps having even greater supermajorities insulates them from defections while they try to make sure that if there is a veto, they can override it. But I strongly suspect that anything that the Republicans coalesce around would have more of a cushion than they need to deal with any defections, if they would have any defections. So the supermajority, I think is kind of a bit of a red herring. The key is that anything that they decide to push to amend 39A or to limit the governor's powers in other ways, they're going to be able to accomplish. And his only argument against that would be that somehow they are infringing on his inherent powers as commander-in-chief under the Kentucky Constitution. And I strongly suspect those arguments would not be very persuasive to the courts. Once the legislature had spoken, that would lend a lot of weight and lead the court to, I think, the courts to see those arguments in a different way than they're currently seeing the arguments when the text of 39A, in my view at least, supports the governor. And if the legislature abandons him, the whole equation changes in terms of the courts. The only other thing I would add to that is that there have been times when the General Assembly either doesn't have its act together or is very carefully trying to make a political point without changing the law, and they can enact a law late enough in the session that the governor can override it, and it's too late for the General Assembly to come back into session and override the veto. So if the General Assembly wants to sort of thread that needle, which I doubt they do, that has certainly happened in the past, and it could be a way they could pass a bill, try to get political credit for it, and yet maintain the governor's powers in place. My expectation, though, is there will be changes made, and my hope is that that will be made by the governor working together with the General Assembly to come up with revisions that both sides can support.
Chris, would you like to respond?
Yeah, I think Sam is right. Obviously, constitutional amendments do require a little bit higher majorities, but I think the Speaker of the House is going to carry the bill to allow themselves to call themselves back into session. And I think what they're going to do is not change the number of what I've heard like 3 different proposals that are being floated right now, and the General Assembly is planning right now. They are holding meetings on these topics, on this 39A issue, on calling themselves back into session. And obviously the constitutional amendment process, we don't have an election in 2021. I don't know if that would even be put on the ballot just for that purpose. Sam may know that, or if it would actually carry over to 2022 to actually be put on the ballot. But those constitutional amendments do not take effect until or unless they're ratified by the majority of the voters at an election. 39A, I think we're going to see legislation on day one. I think from what I'm hearing, they're going to go into session on the first day that they're in session. They're going to run through that Saturday, and they're going to come back 10 days later to override the veto, and that's the plan. I think the governor in some respects has kind of kicked the hornet's nest. And I think he could have, met with the Speaker and the Senate President throughout all this and probably alleviated some of that. I think at this point, they're going to act mostly unilaterally, and I think they're just prepared to override the veto. That's what I'm hearing.
I
feel like we could have a lot of back and forth there, Dan. Before I kick things over to you, Dan, if we can quickly kind of switch gears and talk about enforcement. We're getting lots of questions about sort of the governor's obligation to enforce these orders equitably. And so one writer puts it as, in other words, does he forfeit his authority when he restricts freedoms for one set of people and not others? Comparison of mass gatherings versus churches and restaurants. Chris, let's start with you, and then Sam will get to you in just a moment.
Yeah, I think that's part of it. And obviously, Sam and I have a fundamental disagreement and to be fair to Sam, the courts have a fundamental disagreement. The federal courts do, because you're starting to see splits in between the circuits, which tells me anybody that does Supreme Court work knows that that's usually a recipe for the U.S. Supreme Court to take a case up about, this equitable nature of it. And, we compared the, not necessarily the store shopping with the churches, but some of what the governor was allowing was sitting in an airport Well, what are you doing in an airport? You're sitting close to people, CNN's on TV, you're in close proximity, you're there for about an hour. We didn't see much difference between that and sitting in a church pew in a distanced manner, and neither did the Sixth Circuit. But, I could tell you that, the Seventh Circuit didn't see it that way. The Ninth Circuit didn't see it that way. These issues are being litigated, which tells me we're headed to the U.S. Supreme Court on this ultimately. And then when we look at the mass gathering ban, part of the argument we made, was the governor himself attending the Black Lives Matter rally, and we had photos of him that we put in the record. We said, wait a minute, our guys are criminals if they're protesting and they're holding a protest to his lockdown orders, while he's out there embracing in an uneven manner, messages based on fundamentally their viewpoint. And we've raised a viewpoint discrimination claim, in our challenge to his mass gathering order in the Sixth Circuit. And I think it's more than colorable. I think it's frankly compelling. So, those fights, obviously a lot of the arguments we made in the Speedway case were that discrimination kind of issue. Why could someone sit at the ballpark down the street at the Florence Freedom and attend a ball game, but not sit at the Florence Speedway and attend a racetrack? And it's fundamentally the same activity, which gets into a section of the Kentucky Constitution, Section 2, that talks about arbitrary action. So in many respects, the entire way we've litigated all of these cases have dealt with the uneven treatment. And frankly, courts are far more receptive to that than having a battle with the governor's experts, in this case, Dr. Stack, about the science of coronavirus. That you're never going to win those kind of fights. You have to fight it on the, why are they allowing this? And it's no different than that kind of analysis.
Thanks, guys. Another question has to do with the numbers in this state in terms of the virus. This question points out that this state appears to be doing better than most in terms of total number of cases, deaths per capita when compared to other states. To what extent are the governor's efforts and perhaps his success in slowing the virus, to what extent should that play in this discussion?
I think it is critical. First of all, it helps to undermine the argument that the governor's actions are arbitrary if they are having the desired effect, or at least having some of the desired effect. And it also tends to show that the governor had a basis for what he's doing. But I do want to circle back to this argument about equitable enforcement. That equitable enforcement, I agree with Chris, is essential, but it's more essential in some areas of the law than others. If, for example, as he suggests, there is viewpoint discrimination under the First Amendment, that kind of unequal enforcement dooms any governmental action, because it shows that it is not just arbitrary, but arbitrary in limiting expression. But the notion that it's unequal when you compare worship services, for example, to sitting in an airport, Chief Justice Roberts made clear in his view and in a case in which he it was the critical vote in denying a stay in California, that it's up to the state officials, and we should defer to the state officials in deciding what are the truly comparable activities, and therefore whether it's inequitable. And I think that should be providing guidance to the lower courts, and should have provided guidance to the Sixth Circuit in rejecting the church worship argument, because in fact, worship is not like sitting in an airport. In church, you sing, which sends more particles. In church, you have chanting or call and response. You have activities that are much more likely to spread the virus than people sitting with masks on and not interacting in the way they do in church in an airport. So those kinds of differences, it seems to me, are ones where courts should defer to executive branch officials in the exercise of their discretion. And I think the courts that have seen that have gotten it right.
Sam is correct.
Go ahead, Chris. What are your thoughts? Yeah.
Yeah, one of the biggest debates that has raged throughout all of the federal coronavirus litigation is the degree of deference that you provide the governmental officials. And there has been a raging debate. I disagree with Sam about Chief Justice Roberts' opinion and his guidance, because frankly, you had different fundamental rights being violated based on the political leanings of the governor. You had red state governors, Republican governors. Texas's governor is a good example of that in the Abbott case out of the Fifth Circuit, attempting to ban abortion. And one of the early Sixth Circuit cases that came up out of Ohio was Governor DeWine shutting down the abortion clinics. And I don't think, I'm going to call it the more liberal justices on the court are comfortable with a very, very deferential view of that in that context. Whereas your Democratic governors, we saw the restrictions, from Governor Newsom in California, Governor Spitzer in Illinois, in the Ninth and Seventh Circuits, Governor Beshear in Kentucky, prohibiting church. And our view of the world has been, and I think it's a correct view, that Chief Justice Roberts' opinion, and that was the South Bay injunction pending appeal case, was indeed just the opinion of one single justice. And there was a reason that no one else on the court joined it. And I suspect that reason was no one else was comfortable giving the government that degree of deference when we're dealing with fundamental constitutional rights, even in a pandemic. And I do think the degree of deference is at issue and has yet to be resolved. The Sixth Circuit tends not to give much deference at all. Obviously, the Seventh Circuit gives much greater deference, as is the Ninth Circuit. These cases are still percolating. I suspect there's a cert petition pending on the Elam case out of the Seventh Circuit in the U.S. Supreme Court. They may take it. I suspect they will. And I think these questions are going to get resolved about what degree of deference is due the government in a pandemic.
Okay, last question for both of you guys. Give us a prediction. How do you see this playing out in the Supreme Court in terms of the outcome and also timing on this? Chris, we'll start with you and then we'll go to Sam. Go ahead, Chris.
I think, and I'm assuming we're just talking about the Kentucky Supreme Court in the Speedway case. One of two things is going to happen. Either they're going to issue a decision on December 15th, or they know what all the rest of us know, which is that the legislature is going to moot this out in January with legislative changes, and then they don't have to tackle the issue. In my opinion, this case creates real problems for the court to slice the baby in a way. If you allow Governor Beshear kind of this unfettered discretion, in my opinion, that is there in 39A, you may allow other governors substantial discretion as well. And I got, at least in arguing the case, a feel from the court that they were not necessarily comfortable with that they wanted more limiting principles. But they also wanted the governor to their belief, it was that the statutes allowed, and I think, sections of the KRS outside of 39A allow the governor to respond to this virus. Chapter 211 and 214 of the revised statutes, have entire chapters on disease response. And so, I think there may be some struggling within the court on how to slice this. If you're going to say it's okay to not open the door, because 39A, are you going to allow a governor to suspend the entire state pension system in the future for retirees because of an auto crash on the highway? Because, that auto response is a drain on the budget. And yet that is a defined emergency under 39A. I think the court's going to struggle with that. They may end up saying that this is okay, but I think they're going to struggle with writing an opinion that's not going to open Pandora's box in terms of separation of powers jurisprudence in the state. And I don't know how it's going to turn out at the end of the day. I don't know if they're going to issue a decision in December or just punt and let the case become moot in January. So I don't know.
What do you think, Sam?
Well, I think that was a fairly long way of saying that Chris doesn't want to say what at least I think. Maybe he believes, maybe he doesn't, but it's certainly what I believe, which is that the court will side with the governor. And now I think they may include some language in there about how it's important that this reflects a consensus between what the legislature enacted in the broad provisions giving the governor emergency power and then the governor exercising it, and therefore punting it, but in a different way, punting it to the General Assembly to say, if it doesn't want the governor to have that much power, to go ahead and take action in their session in January or thereafter, and say it's not our job to put limits, General Assembly, on what you did. If you want to put those limits in, we invite you to do so. That's how the legislative process is supposed to work. And I also don't think necessarily that what the General Assembly would do would moot the case. Of course, it depends on how much they change 39A and other provisions, but I suspect they would not limit it so much that it would wipe out all of the governor's executive orders. So I don't think the case would be mooted in any event, just no matter what the General Assembly does. So I don't think the Supreme Court will see itself in a position to really punt the decision by holding on to it. I think what they'll punt, as I said, is in a different way, by saying to the General Assembly, you want to limit it, you limited it, that you created the problem, if it is a problem, by making 39A so broad. Well, we're going to let you fix that problem again if it is a problem. So I suspect they will uphold the governor's orders, maybe with a couple of exceptions. They may think that something here or there went too far, but for the most part, I think that there will be a pretty strong victory for the governor, and that will set the stage for whatever the General Assembly decides to do in January.
Okay. Both of you, thank you very much. Chris and Sam, very, very much appreciate you guys taking the time. And on behalf of the entire Louisville Forum and frankly, the entire state, since it affects everybody in one way or another, we thank you for being with us today and for addressing this important topic.